5, 4, 3, 2, 1, start.
This judgment will dispose of connected appeals number FAO 17/2009 and FAO 14/2009 emanating from the common order of the learned single judge dated 3/2009, by means of which an interim injunction on the plaintiff's application under Order 39, Rule 1 and 2, Code of Civil Procedure 1908 (CPC for short) restrained the defendant Epic Sports Private Limited from proceeding against the plaintiff, the Board of Control for Cricket in India, in courts in England. Stanza. The plaintiff submits that there is complete identity between the cause of action of the notified lists proposed and thereafter actually filed on 3/2009 in the High Court of Justice, Chancery Division, London, and the dispute, which is subject matter of suit filed by ESPL against the BCCI, presently pending in this High Court. By the subject order, the learned single judge vacated the injunction relating to the International Cricket Council and the England and Wales Cricket Board. The facts in a nutshell are that ESPL started a cricket tournament in the name and style of the Indian Cricket League, wherein the competing teams constitute players of both Indian and foreign nationality at domestic and international level. Stanza. It is alleged that the BCCI, by virtue of being the concerned home board regulating cricket in India, publicly opposed the Indian Cricket League tournament and also overtly and covertly took all possible steps to stultify its operations. The ESPL has alleged that the BCCI used its influence on various state agencies, ICC, and the respective foreign home boards to boycott the ESPL tournament, namely the ICL. ESPL filed a suit against the BCCI, in which the Union of India and Karnataka State Cricket Association were also made parties, seeking declaratory and mandatory injunctive reliefs against the defendants. While the suit is progressing in this High Court, BCCI filed the subject suit for issuance of an anti-suit injunction against ESPL, alleging that BCCI had received a notice dated 14/11/2008 sent by the solicitors of ESPL in England. This notice states that ESPL intended to file a suit against BCCI in the Court of England and Wales in the United Kingdom. Stanza. Similar notices were sent to ECB and ICC, who were proposed to be made the co-defendants in that suit. In this suit in hand has prayed for a perpetual injunction against ESPL from initiating any action against BCCI in any other judicial forum in respect of the allegations, subject matter, and reliefs contained and covered in the earlier suit pending before Delhi High Court. An interim injunction was granted on 24 January 2009 in favor of the plaintiff BCCI and defendants number 2 and 3, namely ECB and ICC, restraining ESPL from proceeding with its proposed claim before the UK courts till the next date of hearing. Stanza. Wide impugned order dated 3/2009, the learned single judge made the stay in favor of the BCCI permanent till the final disposal of the subject anti-suit injunction action full stop. However, the stay qua ICC and ECB was vacated full stop. All the adversaries discontent with different parts of the order of the learned single judge have filed their respective appeals full stop. In FAO number 17/2009, ESPL has impugned that part of the order wherein the learned single judge has restrained it from proceeding against BCCI in the UK courts full stop. In FAO number 14/2009, BCCI has impugned the decision of the learned single judge disallowing its prayer to extend the anti-suit injunction against ICC and ECB full stop. Moreover, ICC and ECB have also filed their cross objections in FAO number 17/2009 filed by ESPL, praying that ESPL should be injuncted from proceeding against them in the UK full stop stanza. Suit filed by ESPL full stop. It transpires that the very action which was initially proposed to be pursued against BCCI along with ICC and ECB has now been filed by ESPL, the only change being that BCCI has been dropped from the notified array of parties pursuant to the learned single judge's order full stop. Therefore, substantially BCCI, ICC and ECB are claiming the same relief from the court, viz. That the action in UK be injuncted in toto full stop stanza. We shall first deal with the appeal filed by ESPL. The learned senior counsel for ESPL has contended that the learned single judge has gravely erred in holding that the two suits, that is the one filed in India and the other filed in United Kingdom, are similar in substance and that therefore the UK suit is oppressive and vexatious in nature full stop. It is also argued that such a temporary anti-suit injunction is unknown in law and tantamounts to this court managing the board of a foreign court, which is repugnant to the concept of international comity amongst courts full stop. Mr. Porter has laid great store on the fact that the action proposed in the notice of the solicitors of ESPL in England is substantially distinct from the one already filed and under adjudication in this High Court full stop stanza. It is argued that in the pending Indian suit, the actions of BCCI have territorial bearing in India. For instance, BCCI forbidding local bodies to permit the use of their stadia, banning of Indian players from playing in ICL and withdrawal of pension of former Indian players associated with ICL, etc. full stop. Per contra, the UK suit only takes within its sweep complaints which are contextual to actions taken or intended to be taken in the UK full stop. It is emphasized that the reliefs sought in England are substantially different to those in the process of adjudication in India full stop. Essentially, these claims are based on the UK full stop stanza, Competition Act and the crucial advantage that the plaintiff may have by prosecuting its case in the foreign court ought not to be nullified by an anti-suit injunction full stop. It has also been submitted that the reliefs sought in the English action are not directed only to BCCI but are also against ICC and ECB, which are foreign bodies amenable to the jurisdiction of English courts full stop. Predicted on this argument, it is urged that the English action is a single forum case and that Indian courts should not grant an injunction against actions proposed to be filed or actually filed in courts ordinarily or naturally possessing jurisdiction over the dispute full stop stanza. With regard to this proposition, Mr. Porter submits that the finding of the learned single judge that the proposed action is oppressive and vexatious is also erroneous because, as per the appellants, the courts in the UK are the natural forum full stop. He has also relied on the explanation to Section 10 of the CPC to buttress his contention that even if the second action is based on the same cause of action, the rationale of Section 10 of the CPC will not bar the filing of the subsequent suit in a foreign court full stop. It is also urged by Mr. Porter that the English action ought not to be injected as being unconscionable or vexatious and oppressive only because BCCI, being an Indian party, will be compelled to defend an action in a foreign jurisdiction full stop, since the dispute is between commercial entities having international presence defending their position in the UK for the actions in UK jurisdiction cannot be said to be vexatious full stop. It is underscored that BCCI is the richest board in the cricketing world and therefore the expenses likely to be incurred in defending the list in the UK courts cannot be viewed as oppressive full stop.